Today on the podcast, we have Henry Arthur and Robin Jonde, who are both fourth year law students at the University of Botswana and have participated in the Moot Courts under this program in different capacities. Hi, Henry and Ruby.
Hey, Khwisi.
You have both interacted with the LGBTQI moot courts in different capacities, and I'd love to hear your experiences. To begin with, Ruby, please give a brief description of the case that you and your partner tackled in the moot court that you participated in, and what the themes that came up in that case were.
So the case was about a student who wanted to take a female partner with her to the dance to her high school prom. And she was not allowed to by the regulations of her high school, which stated that you could only bring a male partner to the dance. So the case was about her parents coming to the court and requesting that the rules be abolished and that Adelaide, which was the name of the student, should be allowed to express herself, both in terms of freedom of expression and, yes, and freedom of speech. So the main themes that came out during the moot court was mostly conflicting rights, such as the right to freedom of religious expression, freedom of religion, versus freedom of expression and freedom of speech, which was more about the student being able to bring whoever she wanted to the dance, based on how she expresses herself and her identity. And yes, so expression of her identity. And the legitimate limitations on both of these conflicting rights and how this can come about in a court of law, but also the impact it has on society, on different societies, especially societies that are predominantly religious. So it tackled issues such as social values, traditional values, and how these also play into international instruments and international treaties that have been signed by various countries around the world. And yet these same rights are still being brought up in different cases around the world, as we see in Brazil, where you have protests and marches and um, cases, for example, in America, where the same, very similar cases where male students wanted to take other male students to the dance, and yet they were prevented from doing so, and they faced a lot of ridicule, ostracization from society, and just backlash from society in general. And so all of these were discussed during the moot court itself, like the impacts on society and the impact on the individual themselves. If we were to allow the student to attend the dance with a female partner, what repercussions would that have, or what consequences and impacts would that have on society and on her as an individual? Yes. So all these conflicting rights and how society plays into the promotion of LGBTQ rights, as we already see in cases around the world globally, but also specifically in this case. Those were all the themes that came up and all the issues that were discussed.
That's very interesting. I didn't attend that moot court, but I attended the latest moot court that Henry helped organize and also was in the audience for. Henry, could you tell us a bit about this most recent moot court in that case?
So yeah, you'll find that there's often a common thread when it comes to LGBTQ rights, especially when we try to place real world problems, legal problems that people have in the moot court scenario. So in as much as moot court is well like moot, these are actual tangible things, and the tangible thing that people face is discrimination. So we took the context of discrimination to move away from that of the youth, which is the high schooler in the case of Adelaide. Was this the name, right? Is that how you pronounce the name, Ruby?
Yes, it is.
Adelaide, yeah. Now we had a different person. This was now a woman who was known for her proactive LGBTQ stance, her her social media posts, her very live or colorful identification as being part of LGBT rights. Now, what she's done is she's actually qualified to work for a Christian high school. It's interesting that she wanted to work for a Christian high school, but that's how much of a professional she was. However, even though she met all the qualifications, you find the Christian high school, they rejected her request to work there. What's interesting in that case was that they actually went forth to send her a letter telling her that because of her LGBTQ stance, because of her sexuality, so on and so forth, they weren't going to take her because it was not in line with their Christian values. And then the courts had to then adjudicate whether or not do employers have a private right to choose who they want to hire, or do the individuals, do we have an inherent constitutional guarantee against discrimination? And so by invoking that private right to choose who they want to, was this discriminatory? So essentially the moot court was bouncing around these ideas, the issues of whether or not you have a right to choose who you want to interact with, or whether or not we are a democratic society that subscribes to civilized principles to the extent where we're not going to allow any form of discrimination, especially if a discrimination is made tangible in the and real and the sense of a letter rejecting you, saying we don't like you because, well, basically you're gay. And that was essentially what that moot problem was about. And so we had to get through a lot of logistics in terms of getting it done to ensure that there were enough participants and the right judges who could, and it was quite an interesting affair. Yes, that's my take on it.
Yeah, you talk about, before we get into both the cases, which are very interesting, you talk about getting the right judges. How do you go about that? Maybe give us a very brief overview of what organizing this moot court, what goes into it.
So yeah, essentially this is not the first moot court that I've had to go work behind in terms of the logistics. Even the one that Ruby was at, even though I wasn't there with the watching and whatnot, I had some other duties I had to take care of. But essentially, you need to make sure you have a network of lawyers and judges, so much so that anytime that you need them, you call upon them. And that's the thing with the legal fraternity, the legal community, is because a lot of them are often quite interested in these moot court proceedings, especially because the judges that we rely on, they tend to be those who've actually competed at moot court at an international level, at African human rights moot competition. So even though not all moot courts are necessarily about LGBTQ rights, the golden thread, the common theme tends to be discrimination and protection of human rights. So they're just a call or an email away. Essentially, we need to see when they'll be available, and then we also try to get an actual judge who sits on the bench in our court system to come and participate, especially in the final.
I find it interesting that both of the cases touched on LGBTQI rights in relation or interacting with a religious aspect. And this is quite interesting to me because there's a march that happened earlier this year. Churches around the country marched against something, a bill that was passing. I'm not a law person. Could any of you please give a brief of what happened earlier this year for that march to happen and what the march was against, if you guys know?
We had the famous, now called the Mutsirimang case, right? This is essentially a case in which a man wanted to, I won't get too technical about it. Let me just try and simplify it. But essentially, the penal code, which essentially is the act that prescribes all written laws that are criminalized, because one cardinal rule of law, it's not a crime if it's not written down. It actually criminalized the act of sodomy, a natural act, right? So essentially, what you do in the privacy of your own bedroom was a criminal offense. And the background of it was a case in 2003 involving one Kanani, and he tried to render that provision of the penal code unconstitutional. At the time, they said Botswana are not ready to accept rather homosexual rights. But in 2018, I believe, or it was 2019, one Mutsidi he challenged the constitutionality of the provision, and the Court of Appeal eventually ruled that this provision is unconstitutional. They read into the constitution because under Section 3 of the Constitution of Botswana, no person shall be discriminated based on their age, sex, gender, so forth and so on. And as such, this provision was rendered unconstitutional, essentially meaning that what two people do in the privacy of their own home, whatever kind of sexual activity they engage with, it was deemed to be unconstitutional, ultra virus the Constitution, outside the scope of the Constitution. Thus, it was struck down. So after this court ruling, you find that a lot of conservatives, especially those in the church community, because they want to hold on to their conservative values that are anti-homosexual, they started marching against this ruling, because as the way the law works, there has to be a bill made in parliament, so much so that the element of the penal code is struck off. So they were marching against that. They wanted to make their words known. So it was a peaceful march, I will say that much so. But it goes to show you that even when the judiciary tries to be, to be progressive, to be liberal in the values that they feel that a country should hold, there will always be pockets of those who are conservative, who, even though they might not be outright homophobic, like in countries such as Uganda and Ghana and I believe Kenya, you will find that there are these passive aggressive positions against homosexuals, and that's what they were marching against. But fortunately, I believe that the position of the Court of Appeal is quite clear, and it might take some time, but eventually it will be accepted as standard norm for there to be tolerance.
Ruby, I'd like to know if participating in the Moot Court changed the way you think about LGBTQI rights or human rights in any way. Has it changed the way you think about the law and the way it can protect people?
Yes, I do think that to a certain extent, it has broadened my ideas of how, or like my perspective on how impactful the law can be, but also it made me realize how important it is for society and the community to also accept the law, like to embrace the laws and the rationale behind it, because it's not just about appealing a case or deciding a case or changing legislation. It's about changing people's mindsets as well. And when I did more research into especially global cases in Brazil or in America, it was very important to do more than just change legislation. It was also about legislators, lawyers, community, society trying to change people's mindsets. So education as well and raising awareness. I learned that a lot from doing research for the Moot Court question.
Yes, and Henry, you are talking about how both of you actually are talking about how the law has a part to play in the law and the society and how they interact, and maybe the part the law has to play in this. Ruby, I know you didn't attend the seminar, but I'd love Henry to touch a bit on the conversations that happened during the seminar. We had Mr. Maswabi come in and talk about strategic litigation, especially within the rights of marginalized people and the LGBTQI community. And he mentioned that strategic litigation it's a partnered effort, like it's a network of efforts. It's very sometimes financially unrewarding work that requires lawyers that are willing to put in the work despite not earning as much as they would on the other cases. And do you have anything to add to the conversation that was mentioned during the seminar and the question and answer session that followed it?
Yes, definitely. I'll just get my notes out here. And yeah, so what we got from Mr. Masabi is that strategic litigation, it's essentially a legal tool that has been used to advocate LGBTQ rights in many ways, including decriminalizing same-sex relationships, legal gender recognition, protection from violence and discrimination, and recognition of family ties. So that's the objective of strategic litigation. So what is strategic litigation? So is as with any form of strategy, right? It's essentially a combination of legal, political, social, and communication measures that are used in high-profile cases to achieve structured change in society. What we basically got is that it can be used to raise awareness of human rights violations and socio-political conflicts. So essentially, strategic litigation can be used for national or regional level. For example, LGBTQI cases can be reviewed by the European Human Court of Human Rights or the Inter-American Court of Human Rights. This is in the global context. And then in Africa, we also have the treaties and the African human rights courts that speak towards the protection of LGBTQ rights. So what we got is that some say that strategic education is important because of the widespread discrimination against LGBTQ people, the increasing attacks on them, and the legislative gaps that still exist. So strategic litigation essentially is about recognizing that it's about more than winning just a case or two. Because look at the Mutiriman case that I spoke about earlier. In as much as Mutiriman won the case, there's still that backlash that's coming from society. What do we do as lawyers to ensure that we're able to push towards that final end goal? So this means being able to understand judicial process, being able to understand the type of arguments that we need to make, the legal precedent, and understanding that all of these things, real change is a cumulative of all these processes. And like you said, this can be a time-consuming and not necessarily financially rewarding aspect of litigation, because litigation is expensive and the rewards might not materialize monetarily, at least not in the short term. So strategic litigation essentially is about putting together all these aspects of litigation of the law that will essentially enable us to achieve the kind of change that we want, no matter how time consuming it may be.
I would like to know if these seminars and moot courts focused on LGBTQI rights, as well as the legal clinic, even though I know as fourth years you are not yet part of it. What are the conversations after a moot court of this nature?
So yeah, like after a moot court of this nature, at first it just starts on a technical level. Like, okay, what's the best argument to make to support the applicant? What's the best argument to make to support the respondent? But then after that, these conversations, they seep into our everyday consciousness by asking ourselves, if I was Adelaide and I wanted to take a girl or someone of the same sex to my prom, how would I feel if I was denied this right? Is it fair? Is it reasonable? Is it justified? And I think those are the kind of questions that people really started to ask themselves, because on one hand, you are in a Christian organization. These people protect and love their values. But on another hand, should your values supersede the dignity of individuals? And then we also have to ask ourselves, what is the impact of the kind of discriminations people face? Because one minute you tell yourself, oh no, it's just a school dance, right? But then we start to realize, especially because we're law students, when we're doing subjects like jurisprudence, we understand the impact that the law can have in terms of more enforcing morality, right? So these moot courts, and especially and I also hear from the fifth years that we're doing the legal clinic, these moot courts, these initiatives, they open our eyes to the realities of LGBTQ rights, especially if you are somebody who is not, maybe you're not part of the community, and you don't understand how these people feel, especially because even that kind of term, maybe that is condescending. For example, how do we interact with people who are in the LGBTQI fraternity, for lack of a better expression? And having to also do this moot court also made us realize that we might have to take on clients who have been discriminated against, who have had their lives changed simply because they identify with that kind of sexuality. And I think the long and short of it is that these kind of experiences, they opened our eyes into the real world and how discrimination can come in many, many forms. regardless of the person you are. You might be affected by it in one way or another, form or another.
One thing that I do appreciate and I love that you mentioned is how this is going to seep into your work life, because part of the inclusive justice program, we have held trainings with clerks and judges, and they say the same thing where they're like, it's very helpful because just on the education point, on knowing how to interact with people who may not identify with the gender they were given at birth or have sexual preferences that are different to yours. And I believe that it will be helpful in making people from the community, from the LGBTQI community, feel safe and know that the law represents them as well. The human rights include their human rights as well. What legal developments do you hope to see within this area of the law during your career?
I think legalizing same-sex marriage would be something that I'd like to see in the near future, just because I think that would be an important step towards promoting LGBTQ rights in the legal field, but also normalizing it more within society and within our interactions with each other. Because when you see people getting married openly, having weddings openly, I feel like that is a way of normalizing it within society. And then you'd also be able to limit the amount of anti-LGBTQ protests like what we saw earlier this year from occurring again.
Yeah, definitely. And I think just to piggyback off that, if we do eventually get those kind of enactments, I think I'd like to get to see a system whereby these sort of judicial decisions and even legislature, when they are made, they're actually enforced. Because we all know of cases like the ND case where the applicant wanted to change their gender marker, and even though they got the judgment, it was difficult for them to actually have this enforced at the Omang's office. And I'd like to see a point where the legislation, the legal changes are able to take into account the severity of why it is LGBTQ communities, because they feel so disadvantaged and discriminated, why it is that I'd like to see a situation whereby their rights are also recognized practically, not just in the vacuum of theory. I'd also like to see a situation whereby we have more centers that are geared towards LGBTQ rights, because we're having some progress. Because I believe there was I think, is it Bonella? I don't know, but it took them a while before they even were officially recognized. So I think I like the fact that because Bonella speaks towards LGBTQ rights in Botswana, and I think we've gained some steam, and in terms of recognition of the discriminated sexual minorities. So once we get to a point where legislation is able to fully adopt them under the umbrella for change, and we give a truly purposive approach to interpreting constitutional rights, and in terms of the Bill of Rights that accrue to each and every resident and citizen of this country, I think those are kind of changes that I'd like to see as our jurisprudence continues to develop.
I'd love for you to share one thing that you had never thought of or considered with regards to LGBTQI rights that these activities has exposed you to and taught you about.
So yeah, essentially, especially with let me start off with the Sui Clinic. What I've seen there was that sometimes you find yourself placed out of your comfort zone, because a lot of the literature that we're learning from first year to fourth year until we get to fifth year, not much is spoken of in terms of what it means to actually handle LGBTQ or rather sexual minority client, right? So fine. I mean, it is spoken about in the abstract as the general, but now what the Sui Clinic has exposed us to is the change in the general society that we live in, and how it is more needs to be written about what needs to be done in terms of dealing with sexual minorities, because a lot of the time all we know about is what it means to be discriminated against as a general member of the public. So we don't necessarily have tailor-made solutions for that. And that's what it is. So the seminar on strategic litigation was very eye-opening in that sense, because it allowed me to appreciate the nuances that exist in terms of being present and rather cognizant of the strategy that we need as lawyers and the likes. And then just going through the moot court problems, just organizing it, it forced me to go through and read through what kind of problems that the sexual minorities they likely to face. And I think now just go back to what I said again earlier, just opening your eyes, opening your heart, I guess, opening your mind to what it means to be as part of the sexual minority and to live in what is a conservative society. And now I've been able to appreciate that even in conservative societies, change can be done for the betterment of those who are discriminated against.
I agree with Arthur. I think that it's difficult to put yourself in other people's shoes, but these activities from the seminars to the moot court competitions have really allowed people, sparked conversations that allow people to talk more about LGBTQ rights, but also, like he said, what it means to be in a sexual minority, but also how you can help others and your friends who you may not have really thought about what they're going through. And then now that you do, because you're more aware of legal milestones that have been achieved on their behalf and what is still to be achieved on their behalf, I think that it's important to have these activities because it broadens people's perspectives and it helps you empathize and put yourselves in the shoes of of people within a sexual minority. Like we even had a member of one of the candidates for the UB SRC elections was openly identified as LGBTQ and openly talked about it even during the debates. And some of the topics that he brought up and spoke about really helped bring awareness. And I think that because he was also one of the people who watched the first moot court competition that we did earlier this year, I think that these kind of conversations are important, but it also gives people confidence to continue talking about it. So I think that these activities are important and are very helpful in that regard.
Thank you so much to both of you for making the time to record this with me. I know it's exam week. Good luck. We need lawyers like you out there. And yeah, thank you guys. Bye.
Thank you.
Thank you.
It was a pleasure.
Thank you.